that you have a verdict, is that correct? You'll give the verdict to the bailiff. Madam Clerk, if you'd like to publish the verdict.
State of South Carolina, County of Georgetown, in the Court of Common Pleas in the 15th Judicial Circuit. Case number 2023 CP 2200001, Dawn Marie Plekin versus Raymond Douglas Moody, 389275. And the court has found, as a matter of law, that the defendant intentionally inflicted emotional distress on the plaintiff. Therefore, the issue for you is the amount of actual damage, if any, to be awarded to the plaintiff. You are instructed to answer the following questions. You must all agree on your answer to each question, and the foreperson must sign the completed form on the signature line. We, the jury, all agree, answer the questions submitted to the court as follows. Do you find the preponderance, thank you, of the evidence that the plaintiff, Dawn Plekin, suffered injuries as a result of the conduct of the defendant, Raymond Moody? Yes. If the answer is no, stop here, sign the verdict, and blah, blah, blah. What, if any, is the amount of the actual damage sustained by the plaintiff as a result of the defendant's conduct? Actual damage in the amount of $200 million. I certify that the verdict of this jury in the matter is unanimous, got it right this time, and rendered freely and voluntarily. Foreperson dated 2/25/25.
Members of the jury, is this your verdict? Is there the jury about the plaintiff?
No.
Any about the defense?
No, Your Honor.
All right. Do you wish to proceed further? Gentlemen, where in a trial the defendant in this case has also pled for punitive damages. Mr. Wiley will be given Mr. Willie, excuse me, I apologize, will be given an opportunity to close briefly on punitive damages, and then I will charge you on the law as punitive damages. Yes, sir.
You've heard the evidence in the case. You know that this was not the only time that Mr. Moody intentionally inflicted emotional distress on people, on children, and their parents. And you know that prison time was not enough to teach him a lesson. The judge is going to instruct you on what punitive damages are, and I think this is a very important part of the case. Listen to what the judge says, what these damages are for, and then use your good judgment in sending a message to all the people around the world. In this community, if you come here, not only will we take everything from you, but we will punish you. And there will be punishment on top of the pain that you have inflicted. And that's what the judge is going to instruct you on. So thank you for your time.
Thank you, Mr. Lilley. Ladies and gentlemen, I now charge you on punitive damages. And as you have awarded actual damages, you may now consider an award of punitive damages. Punitive damages are intended to punish the defendant for extraordinary and outrageous misconduct and to prevent the defendant and others from committing similar acts in the future. Punitive damages can only be awarded when conduct of the defendant has been something more than mere negligence. The evidence must establish that the defendant's acts were reckless, willful, and wanton, meaning there was a conscious failure to exercise due care or a conscious indifference to the rights and safety of others or a reckless disregard thereof. If you find that the defendant's conduct was willful, wanton, and reckless, you may award the plaintiff punitive damages. To support an award of punitive damages, the plaintiff must prove by clear and convincing evidence that the conduct complained of included a consciousness of wrongdoing at the time of the conduct. Clear and convincing is more than just a preponderance, as we discussed earlier. It requires proof which persuades you that a party's claim is more likely true than not true. Clear and convincing proof is not in criminal cases, it's proof beyond a reasonable doubt. However, clear and convincing proof leaves no. It means that the evidence is not ambiguous, doubtful, equivocal, or contradictory. Convincing means persuading by proof or argument, causing one to believe in the truth of what is asserted. Clear and convincing proof establishes in your mind not only that the fact is probable, but that it is highly probable. Before awarding punitive damages, you must consider in 4 different elements which may be pertinent to the facts of this case. You must first consider the relationship between any punitive damage award and the harm that has been caused. Any penalty imposed should take into account the reprehensibility of the conduct, the harm caused, the defendant's awareness of the conduct's wrongfulness, the duration of the conduct. Any penalty imposed should be in relationship to the nature and extent of the conduct and the harm caused, including the compensatory damage award made by any other penalty which may be imposed for the conduct involved, including any criminal or civil penalty, or any other punitive damages awarded arising from the award of any amount of punitive damage award may deprive the defendant of any profits bankruptcy. Anything else from the plaintiff?
No, Your Honor.
Anything else from the defendant?
No, Your Honor.
Thank you, sir.